You're welcome back. This is Newsfile. This is your most authoritative news analysis show. And before we continue with the next issue, we have just confirmed with the Electoral Commission itself, double confirmed that a statement has been released, and it is under the hand of Christian Owusu-Parry, who is the Acting Director of Public Affairs. And this is what the statement says, that the Electoral Commission's attention has been drawn to reports in the media that the National Election Steering Committee has been suspended. The Commission wishes to inform the public that the reports are erroneous and should be disregarded. At the Inter-Party Advisory Committee IPAC meeting held yesterday, the 19th of February 2016, the Commission assured the stakeholders, after persistent calls for the Commission to reconsider the setting up of the committee, that it would meet and discuss the concerns raised and inform IPAC of its decision later. This should not be misconstrued as a suspension of the committee. The committee remains in place. Please take note of that. The committee remains in place until a contrary decision is made. The Commission wishes to appeal to the committee members to stay focused as it takes the necessary steps to address the concerns raised. Thank you, Christian Owusu-Parry. And this was issued this morning, obviously, right when this discussion must have been going on. Thank you very much for bringing it to us now. So things have changed. 1 minute or 30 seconds each.
Well,
yes, Honorable?
Something is unfortunate. I mean, this is about the third mistake. The first mistake was the register. The second mistake was the formation of the committee. Innovative, but not inclusive. That was a mistake. And the third one is this statement. All they ought to have done was to say that, look, we are suspending the committee or the membership of the committee.
You're saying that it is a mistake?
It's a mistake.
That they are correcting, they are correcting the information that's been brought by representatives of the party that the committee, yesterday's meeting, agreed to a suspension, which was not agreed.
Well, if the people came out of the meeting, IPAC came out of the meeting with a certain conclusion that, look, the activities of the committee will be suspended until later, until other issues are resolved. They ought to have gone with it. They ought to have gone with it, because they say that will bring back some of the lost confidence in the people. I shudder to think what people are going to say.
Let's hear Honorable Kwating. What do you say?
Look, this is not just strange. It is terrible. I spoke with our rep on IPAC. It says the committee's work has been kept on hold. And therefore I could go out and say this.
Okay, so
I get the same impression.
So the words that were used at the meeting was that the committee's work has been put on hold.
Suspended, yes.
Okay.
Suspended.
And you say that will mean suspended.
Yes. And you see, if you look at all the political parties that are represented on IPAC, they all seem to have come from the meeting under that same impression.
Right. Yeah.
How come that the EC alone sitting in the meeting said, that's not the impression I got from the meeting?
Maybe we should procure the minutes of the meeting. Kofi?
You have the two main parties who are loggerheads over this matter agreeing that the better way to do
something they rarely do.
They rarely do. Okay, is to just put this on ice, let's think again. This is a terrible mistake. And please, Charlotte and the EC, get back and paper this over. Look,
does this not go to the question I asked earlier, that conceding to the IPAC will mean ceding their independence? Or what is the meaning of that independence they get from the Constitution?
They listen to advice.
One, they already made a mistake in terms of the procedure.
Yeah.
Two, only a fool doesn't change his mind. And we are dealing with things which are delicate. Look, my worry with this is the way it damages the confidence of the parties in the leadership of the EC.
Should IPAC be dictating to the EC?
IPAC is not dictating to the EC in this matter. Indeed, IPAC went to the EC, and then the EC gave them an impression. Two of the people who are usually at loggerheads come out with the same impression. The rest of the country thinks that even if this was a good idea, one, you haven't declared their purpose. Two, the procedure was wrong. Put it on ice, let's go back. We are unanimous around this table. Now you bring in this. What will this do? It will create more heat than anything else.
Interesting. Kweku, look, I heard Atik of the PNC, I heard CPP people, I heard almost all the parties coming out of that meeting saying the committee is suspended. The EC says not suspended. What were they hearing
This is,
at the
my
committee?
Joy Online
Yes.
report. And yeah, Obiama said the party was satisfied with the suspension of the activities of the committee. Bernard Mona says we are partners in shaping the destiny of this country, and said that the EC did not even know what, they had no justification for setting up the committee, that they didn't know. It appears the EC itself is not certain as to what it wants steering committee to do. For some people maintain that even the NDC was unaware of the setting up of the committee, that the media made it public to drew the attention to it. He told Joy FM's Kwachi Afre Noamon's top story that the EC was expected to put his house in order and provide the parties with a justification for the decision. Did we go or did we come? I'm surprised.
Today.
I think that we should always try,
But Kuku, what's your understanding from what they were saying? Suspension of the activities of the committee, is this the same as the committee having been suspended?
Essentially.
I think that it's become stillborn. This committee has become stillborn. Look, you need the confidence and the support of all the stakeholders. And because of what has happened, there's a problem. So you beat a retreat, you get everybody together, discuss it. If there's the need for it, you redesign the architecture.
You don't agree also that it's a dangerous precedent to allow the parties to dictate to it?
Then they shouldn't have even gone and sat down and formed an electoral reforms committee to come out with all those far-reaching comments. The EC on its own could have done that.
Okay. Thank you.
What better way to save face than the party saying that for us, we think you should put
and make
this
that
on
your
ice
excuse.
and then put your house in order.
Okay, right. So really, the issue we're returning to before the statement was issued was about the the government's attempt, plans, which has now received some extension. Actually, by now, by close of work yesterday, it would have been over, and Parliament would have gone to consider the bill that is supposed to come into effect to allow national security to listen into your communications or conversations with legal authority. And somehow, after the protestations, so to speak, by CDD and other civil society and media, as well as individual members of this society, Parliament appears to have listened and has extended the time that you can bring your inputs into that bill to 2 more weeks. It is the Interception of Postal Packets and Telecommunication Messages Act 2015. And there's a memorandum that accompanied it, and the memo that accompanied it said, among other things, that the object of the bill is to enact legislation for the lawful interception of postal packets and telecommunication messages for the purpose of fighting crime, suppressing organized crime, including money laundering and terrorism, narcotic trafficking, identified theft, and generally for the protection of national security. The issue of armed robbery, terrorism, money laundering, and narcotic drug trafficking has become a real threat to public order and to the safety and well-being of individual citizens in Ghana, and so on and so forth. So this is the purpose for this law. Kofi, how do you understand the hue and cry that is following this law that is coming in? And, I'm asking also because clearly on the basis of Article 18, particularly Clause 2, you have a right not to have the privacy of your communication invaded, but there are certain limitations. There are certain points at which the state can come in. So what are we worried about?
The Constitution is enough. Whatever government or the security agencies want to do, the Constitution is enough to allow them to do it. What they are asking for is a legitimization, to give them an extension to invade our privacy whenever they want to. Now, I was telling the parliamentarians that this is brutum fulmen. It's a lot about nothing, because the day you pass this bill, I will go to court and have it declared unconstitutional. Because no statute overrides...
Brutal fulfillment is something you can't enforce.
An empty
Something
thunder.
useless.
Yes.
So what do you mean this is brutal
Like
fulfillment?
Because it is
They will pass it
unconstitutional.
anyway.
If you pass it, we will go to court. Look, security agencies listen to our conversations anyway. And
They
there
do?
is provision within the... If you can go to a judge, okay, and get the room to do that. And the essence of security or covert operations is that they are usually on the periphery of legality. But that's why they are done underground. If there's no problem, you drop it. The US government has been listening to everybody. Okay? But if there's a problem, okay, then you take certain, measures. There is enough room presently within our law for our security agencies to do whatever covert, whatever they want to do and get things done. Here, what they are trying to do is elevate it to the point where they can infringe on your rights, and then if something goes wrong, they can hide under this. It is always the excuse of despots and dictators that they are going to protect the mass of the people. And with those excuses, they appropriate rights with which they oppress the same people. This is a classic case. It's not just illegal, it's dangerous.
Those are
It
very
should not
harsh
happen.
words.
No, listen, look, read history. Okay, despots and dictators always use the excuse that they need more power to protect the masses. And when they get that power, with exactly those powers, they oppress them. Okay, there is enough in our constitution today to allow our security agencies to do whatever they want to do. One of the arguments I've heard is that maybe they got to know the thing today and they need to do something today. Well, if you are serious as a security concern, then you should not be caught by surprises. You should not be acting on emergencies only. And indeed, in this country, everything is an emergency. Everything has to, be done on an urgency, whether in parliament or procurement. Now security matters too. So this law is directly against our constitution. No statute is stronger than our constitution. We think there's sufficient room within the constitution for them to do their work. This is not necessary. Indeed, it can't do any good. It can do only bad.
Kofi, how can this law be against the same constitution that says the privacy of your communication is protected, but there is lawful excuse for that privacy to be intervened or interrupted? That is, if we want to invade your privacy for purposes of, crime, public morality, and so on and so, national security, and so on and so forth. So,
inherent in those provisions is a process required. So the person who is invading your privacy must show that they had sufficient grounds upon which to do it. And I am saying that that gives them room to do what they are trying to do here. What they are trying to do in this bill is to say, we don't need all these things. I don't need to prove that I suspect crime. I can just go and listen to anybody and everybody. And if it turns out that I shouldn't have listened to you, this becomes my defense. So what I'm saying is that that particular provision in our constitution is what they need. If you have sufficient suspicion of crime about to be committed, being committed, or whatever, and that's why they are a security agency.
Right.
Today they have cameras all over the city. Okay, they do all kinds of things you and I know, some of which are illegal. We allow them. Why? If they don't find anything, we go away.
Okay.
But if you find something, you proceed on it. So this again can do no good. It can only do bad.
right. And the provision of the Constitution I was referring to is Article 18. And Article 18:1 says, every person has the right to own property either alone or in association with others. Sorry, that's not what I needed. 18:2 says, no person shall be subjected to interference with the privacy of his home, property, correspondence, or communication, except in accordance with law, and as may be necessary in a free and democratic society for public safety or the economic well-being of the country, for the protection of health or morals, for the prevention of disorder or crime, or for the protection of the rights or freedoms of others. Kofi is asking you, why do you need this law?
But that is except it is in accordance with law. And what is the this is a constitution.
There's no
why
the
do you
law.
need new law?
So you are making it for
No,
the law.
This law
Except in accordance with law. And what is the law?
is spelled out there.
No. This is a constitution saying that nobody's privacy can be intercepted except in accordance with law.
So now you are making
A
that
law. That's what we're doing now. That's not, two, this is not an activity or this is not an act of a despot. In fact, this certainly is no act of dictators.
Okay, give me just 1 second. You say except in accordance with law.
Yes.
And the memo says this is for the purposes of stopping organized crime, terrorism, money laundering.
So the purpose
Just
is
hold it 1 minute.
Yes.
When you read the Money Laundering Act,
Yes.
don't you see clear provisions that allow you to do what you're seeking to do now? Again, when you read, for example, the Money Laundering Act, the FIC, for example, the Financial Intelligence Center, they have the right to call a bank or any financial institution to put a freeze on your accounts.
Yes.
IOCO has those powers.
Yes.
When they feel that there's anything that has come into your account which is tainted,
Yes.
there's money in there which is more than what you earn as an individual, they can freeze that account.
Yes.
And they can go back to the court within 7 days and to confirm that freezing.
Yes.
And then you can go and now say why it should not be frozen. Beyond that, read the Electronic Communications Act.
Yes.
Clearly, there are things that you cannot do. These laws do exist, don't they?
Yeah, they do exist. Okay? So first of all, there are two things here. If this law we are seeking to pass becomes inconsistent with the already existing law, then to the extent of the inconsistency, the new law will be deemed to have done what? To have amended them. If the law is expansive than the already existing law, then we are expanding the frontiers of protection.
What gap are you filling?
So that's just a law.
What problem are you solving? What do you want to do which you can't do now?
The problem we are solving is dealing with present realities.
No,
Which one?
He has recast my question in a summary.
Yes.
What gap are you feeling? Is there a gap?
There's a gap.
Where is it?
And the gap is that we are dealing with matters in transit. We are dealing with terrorists who move by seconds. We are dealing with people who post things for which things must move within 48 hours or less. And that you need a court order to be able to intercept.
Which you can
And
get.
we are saying that such parcels should not move on a Friday afternoon when the courts are closed. That you will need to detain until Monday morning when the courts have opened. We are saying that this law is consistent with what exists in the Committee of Nations, of Civilized Nations. Indeed, when we were looking at this law, I Googled up the law in Britain. It's more expensive than this. I Googled up the law in Malaysia. Go to the internet and Google out the title of this law. You will see it in many civilized nations. So, to appear to say that, and I don't think that you can, by any shred of imagination, say that the British administration is despotic or acting arbitrary. You cannot, by that stretch of imagination. Indeed, the fact that we are
we in a hurry to do this because we have brought the Gitmo 2 upon ourselves and we can't monitor their communication?
No. We did this. First of all, we can monitor communication.
So why do you
But we have to go for a permit. We don't do. The law just read.
Now you don't want the permit.
The law, yeah, we
want to be able
monitor.
to just do it
And
without
everybody monitors. Indeed, America is the most intrusive society in this world. In fact, it's an anomaly.
Honorable,
in
you
America.
just said
what I'm
that
saying is
you
that,
can do this thing now. You
what I'm
monitor
saying that,
communication
so we are
now.
expanding the
You want to
frontiers of
remove the
protections. We want Ghanaians to be safe and secure.
You are trying
We
to
want
protect
to,
me
yes.
by listening to everybody's conversation.
So that when
including my private
people
conversation.
put cocaine in yams, we are able to intercept them immediately without going to court.
Honorable, can't you do that today?
When people are talking, I mean, if this one should have been in place, so that when people are conspiring, you are able to get them before they strike. We are being proactive. This law is being proactive.
Do you see the potential abuse of this law?
Every law has potential abuse.
Because as we sit
This
now,
has wide-
the law, the Anti-Terrorism Act that empowers the FIC to call a bank and ask them to freeze your account, IOCO can freeze your stuff and all of that, we know how they abuse it. It's abused to the extent
Terribly.
that when they confirm the freezing of your account, the law says within 48 hours they are supposed to inform you that they have done this. Sometimes they never do it. They just go freeze it and go and sleep.
So every law can be abused. It requires the vigilance.
I just
of the
need to
victim.
target you. Honorable Inusa Fuseni, I have an issue with you. And then on that flimsy personal problem, I go and freeze your account.
So I go to court and say that you have no legal or otherwise, no legal reasons or grounds to freeze my account.
So something help me.
And
Now-
I call for the evidence.
Now you
you are frozen my account.
All right, but let me explain. You are inverting the power balance. Today, you have to give a reason why you have to interfere with my privacy. What this law is trying to do is say, I don't have to give a reason. I interfere with your privacy.
But we do that every
Then
day.
wait.
Ben,
No, wait.
When
Honorable,
you
help
are
me,
driving
help me.
on the
No,
highway, Section 10 of the Criminal Procedure Act, you are driving on the highway, you are in transit, and the policeman or a policeman or security man has reasons to believe that you are a fugitive, you are committed a crime, and he doesn't need a court permit to arrest you.
We all know as lawyers.
Except that he sends you to the nearest police station. So it's the law.
No,
Okay,
Honorable,
hold
in
on.
that
Just
space,
hold
the
on for
police
me.
have those...
Hold on briefly for me now.
Yes.
Now, I don't know how Kweku looks at this thing, but don't you see a certain difference? For example, when you take the Electronic Communications Act, the police have frequently gone to the circuit courts because the law allows them to go and ask for power permission to go to a telco to get your telephony records. Sure. But the thing is that they get a record of the fact that you have made contact with, I have made contact with Kofi Bento. We have spoken, but there's no evidence of what we discussed.
Content.
Don't you see the importance of this so that they'll be able to listen in and know exactly what we discussed?
It's scandalous. I can't believe that we want to bring this and we want to defend this. First, let me explain this. I remember when the NPP administration was in government, I was a special assistant to the finance minister. There were instances where we needed to report matters to the police. And then they said, we need to go to court and get a permit to get this kind of information from the telcos. So the practice now is that national security government, you can get any information you want. That's the current operation of the law. Just go to court, and I'm yet to hear of an instance where they've been to court, the court says, I would not give you. So there's no difficulty. As far as I'm concerned, there's no gap to be filled.
But I'm saying that one, when you go to court, you get something that tells you that Kweku Karting called Sami Odami, my producer. He called him today at 2 a.m. He called him again at 5 p.m. He called him again at this time. But you don't have the information.
Oh, well, I can imagine that if the telecommunication service provided have the content and national security went to court and said, I want the content, and the court granted it, that would be it.
So, in any case, you just need charge to arrest.
Exactly. So what I'm saying is that at the moment, you can do that. You can even get the content. You can, if the court says, yes, given the reasons you have given, we think that the 5-minute conversation between this man and this man, if the service providers can provide you, go for it. You can do that. What is new now, and that is in section 4, subsection 3 of the Act, and if I can read it.
It's a bill.
Yes, go ahead.
Of the bill, sorry. Despite subsection 2, which says you should go to court and all that, the National Security Coordinator may, where there is a need for urgency, orally authorize the interception without a warrant of a postal packet or a telecommunications message, and then it goes on and on. Wow. Now, what I'm saying is that we don't need this. There's nothing here that says
potential for abuse.
There's nothing
There's
here.
a caveat.
Please, let's allow him to speak.
There's nothing here that says that it's on a weekend when the court is not sitting.
It's the caveat.
As you said.
Please, let's hear him. Let's hear him.
There's nothing that says when it's a weekend and the court is not sitting, you can do this. It says they can intercept it in 48 good hours. When they would have tapped your calls and done whatever they want with it, they could now go to court. They go to court, or they might even not decide not to go to court. After 48 hours, they say we have withdrawn the interception.
And they do that.
And what it means is that the National Security Coordinator appointed by government can say that, look, this particular journalist, the way
this particular politician
or journalist, the way they criticize government, we want to know the activities. And then all they have to do is orally, they pick a phone call, they say it's an MTN number. So they call MTN and say, this man, we need to listen to him for the next 48 hours. And the law is saying that the telco must comply. And there's a second.
Why should I be afraid if I have no any wrong motives for the things I do as a journalist?
But why should you
Why should you
want
have
to
human
listen to my
rights?
privacy when the
Why
Constitution
should you have
says
human rights?
don't get in the way of my conversation? Why did we put it there? As human beings, we are entitled to some privacy.
Right.
Why should another man be able to? I can listen to his, but he can. If he's a politician, he's competing with me. He's able to tap into my calls, listen to my strategy, everything.
Yeah.
If maybe turn out that
No, don't protect
So the point I'm making is that they don't need this. If this thing comes, we would seek to. When I say myself and others who think like me in Parliament, we seek to bring an amendment to repeal this part. If it is not repealed, we will vote against it. And not just that. I think we must mount a national campaign to say that government wants to start listening to people's calls. We should not allow it. This is something we must never
So
allow.
what are you saying? Complete, not allow, or refine it?
I'm saying that this provision that says we can listen to your call anytime for 48 hours must be removed.
Okay.
The law as it is now is working fine. Yes. I do not see the gap to fill. I do not see what issues have come up that warrant such an unnecessary law. Now, there's a second point. You know, the law also says, section 17 says that if, for instance, the National Security Coordinator wants information from Airtel, they say, Airtel, this man's conversation, we need it in the next 48 hours. And Airtel says, well, the nature of his communication is such that we need to spend so much. The law says then the telco must bear it. When the National Security Coordinator, for their purpose, public policy, let's even grant that to them, says that they want to intercept somebody's communication. They say where it costs something to the service provider, you, the service provider, find the money to do it. Now, what kind of law is this? In an election year, you want to bring these things.
Hold on briefly.
Just to signal that we will resist.
Hold on briefly.
And
he says in an election year we are bringing this, and people are asking questions really. In an election year, we have brought in the LI 224 by the National Media Commission, which now gives the National Media Commission the authority to literally shut down your radio or TV station. Go check that law clearly if you have not paid attention to it. But there are very good aspects of that law that will sanitize the ugly noise in our media space. Hitherto, the National Media Commission couldn't punish you, so to speak. It was toothless. Now, if you misbehaved and you were reported to them and they sat on your issue, gave you the opportunity, and they ruled against you, they could slap a fine on you. If you don't pay the fine, you could go to jail. Sometimes upwards of 10 years, you could get into jail, or your station will be shut down. Kweku, is it not interesting that when government wants information from us, we're in a hurry about it? But when we, the citizens, we want information from the government, we say, pass the information bill, right to information bill. It's been there for how many years? Nobody cares.
Yes, maybe 15 or so years now. See, no government, no state or public agency wins this kind of debate, because everybody is very protective of their privacy. Yeah. So ordinarily, they don't win. But I've been asking myself a certain question, and it's because I haven't done more research on this matter. I ask more questions. The Anti-Terrorism Act,
right,
2008, the miscellaneous matters, that is section 34.
Correct.
1, intercepted communications. A police officer not below the rank of an assistant commissioner of police may apply ex parte to a circuit court for an order to intercept communications for the purposes of obtaining evidence of commission of an offense under this act. 2, a police officer not below the rank of an assistant commissioner of police may make the application only with the prior written consent of the minister. 3, a judge of the circuit court to whom an application is made under subsection 1 may make an order for the prevention of crime upon reasonable grounds. 2A, require a communication service provider to intercept and retain a specified communication or communications of a specified description received or transmitted or about to be received or transmitted by the communications service provider. B, authorize a senior police officer to intercept or listen to a conversation provided by a communications service provider. And I checked the Hansard proceedings in the course of this Terrorism Act being debated, deliberated on, and then enacted. And then I realized that there was virtual consensus on this thing. Look, it means that as we sit here already, there's a legal regime for what is being proposed. There are some, if I read the bill, I can see that this time not a circuit court, it's a high court.
Right.
Okay? There are a few differences here and there. But essentially, it appears that we've allowed a situation where there's already a legal regime, an act of parliament, that provides the state.
Not actually one act, there are about 4 different laws.
You've mentioned some.
Plenty. Yeah, but there's a
And
the police can do it.
No, I'm coming. We'll come to that.
Wait,
No,
Okay, I'm sorry, go on. Sorry.
we'll come there. But I'm saying that what it means is that we are already at risk. I'm suggesting.
We have already accepted that risk.
No.
Hey,
No,
Please, can we stop interjecting?
yes, to
Yeah,
the
let's
extent
have
that
it.
we sat down, we allowed the parliament of this country to enact this law.
Right.
And it's how many years gone?
so long as you apply to the court,
You
I still have no
There's a
problem.
defense there.
But this one, you apply to the court
Yeah.
as well.
Yeah.
Even the oral authorization one is subject to 48
8
hours
hours.
thing. Of course, there's a difficulty there. No, there is, it's in the bill, but there's a difficulty.
48 long hours.
Yes, there's a difficulty. I'm not for it.
sure.
I'm saying that even I've spoken to some people in the telecommunications service providers area, and their view is that, look, it may be difficult even to authenticate the evidence of the oral authorization.
Okay.
And that if that happens, it can drag them into litigation with some of their clients. So there's a gray area there. So even that is not a cure as such. But those are some of the new elements that the bill is bringing on board. But I'm saying that substantively, we are already at risk.
And we should not even be just interested in the 48 hours. He read section 31. If you read before 31, section 30 thereabout, you read things about when institutions they are supposed to submit what you call suspicious transaction reports. And they are supposed to do that within 24 hours when they have suspected that there's some transaction going which is not good. And the EFIC would make a request and you are supposed to comply. If you don't comply, you could go to jail.
Yes, so you see, my view is this. If we are opposed to this new bill, getting it transformed into an act, we might as well begin to taking a look at the old ones that we have passed.
Okay.
Maybe.
Because essentially we are at risk.
Okay.
So I don't see why we should ignore the risks that the old acts bring on board and just focus on this, even though I can see a certain element of consolidation and expansion with this new one. I can see it. Okay, so let's be very careful. Now I believe that when Parliament begins to, because it's clear that it's gone to the floor, to the House.
Right.
It means that the House is going to deliberate. It's important that civil society exercises a higher level of vigilance. Even outside Parliament, we can have our own agitations and deliberations and things. But really, the way our institutional, the parliamentary system is structured, I can see a situation where the majority are going to push this thing through.
Okay, so like we were saying...
Can I come to this? We may as well take the bill. There are a lot of problems with the bill.
Okay.
In various sections. Even the question of serious offenses. What are they? The ones that we know are captured. But there's also a certain category that if you are not careful, many other things will be brought in there. We talk of fighting crime generally. What do you mean by that? If you go to the purpose section. I mean, if you look at the...
Undefined.
Serious offenses, according to the EOCO law, which we passed in 2010, are listed, quite a good number of them.
Yeah. Section 20.
They include terrorism financing, money laundering, human trafficking, people smuggling, sexual exploitation, illicit trafficking in narcotic drugs, illicit armed trafficking, trafficking in stolen and other goods, corruption and bribery, serious fraud, counterfeiting, piracy of products, smuggling, extortion, forgery, murder, grievous bodily harm, armed robbery or theft, and so on and so forth.
Yes.
You see,
Okay.
there are as you read the law, then you come, across some of these areas where clearly we are at risk. But by some grace, we've managed so far. In all of these laws, however, there is a small issue. The issue is this, that the person who will seek to infringe on your constitutionally guaranteed right has to go and get a certain permission or give a prima facie case, create a certain situation before another person so that that person will be granted that power. And Honorable just spoke about the police. They have the widest powers in this country. We have tolerated them because so far they've managed themselves in a certain way. What this bill is trying to do is to invert the power. Now, orally, and Kweku has just spoken about the difficulty in authenticating an oral instruction. Okay? Now, these are the nooks that you create through which people pass to just infringe on people's rights. And anywhere these things, from Nazi Germany all the way down to next door Togo, okay, these are the things that have been used to totally damage society. So we are simply saying this, there is enough law, even those that put us at risk. And what this one is simply trying to do is remove everything that the person who will seek to infringe on your right will need to do, and just freely move and go and infringe on your right, 48 hours of doing so, and then you have to go and defend yourself. Once you're defending yourself, it may be going on.
We need to take a break here, and then we'll return to deal with Smarties matters, and then move on to AfriWave, the license that said will not be with you.
You said enough. Because and I love Kweku because he uses the terms that we cannot use.
Right.
This is a consolidation and expansion of the law.
In fact,
so why the new addition?
Consolidation and expansion.
Why the removal of the restrictions? No. Why expand something which is already
even in your Data Protection Act, you have exemptions that include,
It's amazing.
The data that is protected. You have exemptions that include for purposes of public order, public morality, and all of these things.
We accept this.
You don't need to.
We accept this. I've looked at this law. We accept it because we have always thought that in order that you can infringe here, you go to court.
Right.
That is how we have always.
My last point is the most important.
Let me tell you something. In 1985,
hear me one day.
When Britain was passing the same law, the same arguments were made.
Today, there's a case. My last point. Honorable, note this. You pass a law, and sometimes you assume that you will be in power forever.
No,
I'm telling you something, and let's note it because we stand in the middle. Tomorrow you will be on the other side, and this is the law that will be used against you.
Thank you very much.
That's why we have been warned against.
So be careful.
Don't pass a law thinking that you'll be power.
So we take a break here. We return to talk about the Smarties and how smart they have dealt with the issues as far as the bus branding is concerned. And AfriWave is a key issue that we need to bring a closure to on the platform today. This is Newsfile. We'll be right back.
No good for you.